right. So back here at home, New York prosecutors are in a battle to get their hands on the president's tax returns, and they are citing reports of, quote, protracted criminal conduct at the Trump Organization. Meanwhile, attorneys for the president are arguing that the subpoenas for these returns, the subpoenas are entirely too broad. So we want to bring in Keir Dougall to talk a little bit more about what's going on. Keir, you got to look at the arguments that New York prosecutors are putting forward to get access to these tax returns. Can you give us a sense, based on what you've read, what the scope of the grand jury investigation is? Can we sort of glean any nuggets from that?
Yes, the recent arguments by the president's attorneys about overbreadth prompted a response and some more description by the New York District Attorney's Office about what they're actually looking for. And so, Anne-Marie, you correctly noted that they are arguing that they're looking at possibly extensive and protracted criminal conduct. So we had previously heard, of course, about the porn star hush money payments that Michael Cohen told us about. But when he testified as well to one of the more common types of fraudulent conduct, which is related to seeking loans and paying your taxes. So a pretty common scheme is to make yourself look rich for the banks when you want to show them you have plenty of ability to pay a loan back, but when the tax man comes, you want to make yourself look poor. And so reading the district attorney's arguments and reading the public reports that the district attorney's office is relying upon, it looks to me like that's one area that they're focused on. You'll recall in his congressional testimony, Michael Cohen said that there were inflated statements of finances that the Trump Organization had created.
Yes, totally. So we discussed this a little bit last month when the Supreme Court actually weighed in on this case and concluded that the president is not immune from criminal subpoenas at the state level. And then what the Supreme Court did is bounce the case back down to a lower court. Many interpreted that as a loss for the Trump Organization, the Trump administration. The Trump administration sort of had a different spin on it. So I want to ask you, does the decision by the Supreme Court have an impact on this case?
Yes, it does. I think the watchword here for the overall that the Supreme Court instructed was that the lower courts, when considering a claim like this, a contention like this by a state district attorney's office for a president's personal papers, should be extraordinarily careful and should provide any president, including President Trump, the opportunity to make some additional arguments based upon his or her position as president. Will this interfere with the president's Article 2 activities? Is it an effort by a state prosecutor to try to manipulate the president's policies? These are important questions. The Supreme Court directed that the lower courts now consider them. Also, the Supreme Court said that any president, just like the rest of us, has the ability to claim, if there's a proper basis for it, that any subpoena like this is overbroad or has been issued in bad faith. So those are the major takeaways from the Supreme Court opinion, plus that the president is not immune from a state court prosecution and, like the rest of us, must participate to find truth.
So prosecutors have been accusing Trump's attorneys of, deliberately dragging this whole thing out. And of course, his attorneys deny that. But, it occurred to me that perhaps there could be, a number of reasons why dragging it out would work in favor for the president. Perhaps it's legal. You can tell me, is there a statute of limitations sort of situation? It certainly could be political because we have, an election coming up, and perhaps this is just the sort of thing that a president seeking re-election does not want the general public discussing just months before they cast their ballots.
So, Anne-Marie, you bring up a great point, and it leads us to the old saw that justice delayed is justice denied. And certainly, I think the president potentially could benefit from both of those things. Pushing this beyond the election, as a political matter, I think would be helpful to the president, as well as there are statute of limitations issues. The New York District Attorney's Office is particularly concerned because in a case like this, there are potentially multiple entities and people who could be a part of this extensive and protracted, as they say, criminal conduct. And so the statutes of limitations are running not just with respect to the president, but with respect to those other people. And the grand jury is going to want to separate folks. The folks that, if there is wrongdoing, is going to want to identify them. But if there is, there may be people or entities that didn't do anything wrong. And getting this information will help to cull the innocent folks out of this investigation and focus on anyone who committed any wrongdoing. So the stakes are high for the grand jury.
So, this conversation surrounding making the president's tax returns public has been going on basically since he ran for office, since before he was the president. There have been many different scenarios in which, whether it was through congressional subpoenas or, now we've got sort of the state level stuff happening. There are many different avenues in which people have tried to gain access. So far, it hasn't really happened. What is the likelihood of, do you think, the public ever seeing the president's tax returns? Say if this state case continues, would those tax returns even be made public?
That's a great question, Anne Marie. And of course, we know that the grand jury proceedings themselves are secret. But the way that tax return information might become public is really two routes. One is if the grand jury issues charges, an indictment might contain tax information on one of the theories that we've talked about, that the tax returns look different from the bank loan applications as a way of showing that, there was fraud involved. The other way is, again, based upon charges being issued by a grand jury. If those charges went to trial, if a defendant was charged and contested them and there was a trial, the tax returns or tax return information could be admitted and entered into the record during a criminal trial. And it's at that point that the public would get a potentially very good look at what the information contained. The third route is a leak from the grand jury. Those are rare, and they would be a crime, a felony, if they occurred. So there's a strong incentive to prevent the grand jurors or anyone relating to the investigation from leaking the information.
All interesting stuff. We're watching closely. Keir Dougall, thank you so much.